West. Welcome to Damu Kiwe Conversation. Hit that like button on your way in. Share, tell a friend. Y'all in here with y'all, Kiwe pop star Deuce Sims. Y'all should be on his way as soon as he can get up in here. Until then, I'ma hold it down. You know what I'm saying, for my brother, and we gonna get into the content. Hit that like button, man. The YouTube streets is crazy. The IBM team appears. You never know what on YouTube, what's real and what's fake, right? Plays being run, especially from that side, appears to be having disagreements with the Crip Cop and CS2 Back. Hold on. Before we go any further, let me make sure I do this as is contractually obligated. You know what I'm saying? The like button. We got a white pop star. Yeah.
M's for holding it down. Till I came around, man, you already know what it is.
Nah.
Oh. We are the hottest line on YouTube right now. And the voice of the culture and the West Coast. Salute to the chat. You already know that's where it's at. And salute to the mods, the Blue Branch mods, that is. They always on their job. And salute to the friends that tapped in. If a friend told a friend to tap in, make sure you like, comment, and subscribe to the content. You already know what it is, man. Y'all see the title. We finna get after it, man. We sit with Deuce M's, the Don, and Yael, the Kiwe Pals, Damu Kiwe Conversations.
Well, that's a fact. Hey, y'all hit that like button on your way in. I see y'all slow to get in here. Papa say they want you to stop. Keep going, though. There's no such thing as running too much content on an individual who claim to be street but a rat the whole time. Keep mashing. The CS2 Back shit is starting to reach more. Hey, man, appreciate that. And I'm glad to hear that. And that kind of helps motivate us to keep us focused, to not letting up, keep our foot on their throat. I'm going to call y'all back. Salute. Edward Bell, salute to y'all homies. Strong 100 from Shreveport, Louisiana. Free the homie Big U. Hey, yeah, shout out to Big U. Damu and Kiwe is the realest, and them chucks stay active for sure. The G-Mac. Winning weirdos in this chat, and these birds need to get a life. For real, troll dog. Well, sound like you, the weirdo. Your name is a troll. Salute to Tony Brown. Ricky, salute Dukes, y'all, and the Damu and Kiwe fam. Not only the realest in the West, but the realest on the net. Keep separating the real from the fake. Hey, man, appreciate that. And I couldn't have said that better myself. Ricky, why Wack always calling the man that he's beefing with a rainbow? That's Wack. When Wack's the one taking whole fingers up his ass with that come hither motion. Come hither. Oh, man. Blessed one. What's up, homie? Peace, love, and light. Queens and kings. You know what I'm saying? Selena, salute to the chat. Shout out to the whole Blue Rich mob in the chat, because the chat is where it's at. Miss Lisa, what's shaking, everybody? They slow to get up in here. Brim Shifty, keep lacing our chucks with that real shit. Hey, we ain't got a choice. You know what I'm saying? Spirit Wonder, what's up with it? Salute to the chat. Raw 57, pitiful. Salute to the homie Deuce Sims. Dobie, what up? Megan Davis. Hey, y'all. These nuts. WACK100 is CS2 Back. Young Ant is a rat sympathizer. Goofy. Damn. Nisi Pot. Salute to Damu and Kiwe. You know what I'm saying? Selena. Shody Doo-Wop. What up, though? To the DMCA conversation. Memphis on the check-in. Salute. Salute to Memphis, man. You know what I'm saying? I'm hoping y'all hitting that like button on the way in. Young Roan, aka Baby Dig, what it do, family? I'm in here. Let's talk about it. And we is gonna talk about it. You know what I'm saying? Weirdos, especially the females. Oh yeah, let the troll dog hang up in here as long as they don't diss no hoods and nothing. Let them stay up in here. Let them keep on. You know what I'm saying? Matrix 2030, salute. You know what I'm saying? It'd be real weird. But look, we're going to get into this content. Matter of fact, let me send this because Selena was supposed to read this, bro. She thinks she was getting up off of something yesterday. So I'm going to put this in the chat, Selena. And you got a copy because you sent it. So, Selena, jump on that StreamYard link. You know what I'm saying? And help us get an update on the Worldstarhiphop lawsuit filed by WACK100. No. You said tomorrow. No. We're not doing all that.
Selena,
Yeah.
bring your ass up here.
Yeah, she offered that.
Hey, Belina. Hey, bring your ass. Hey, Belina, bring your ass up here, or I'm gonna have to ridicule you.
So you know,
right now.
So now you I seriously am. No, you supposed to thought about that before you Kid the Barber, salute. Before you volunteered that yesterday. Yeah. How long do you make it home, Selena? Cause see, we ain't taking no Indian givers. You know what I'm saying? Mr. Buka, your microphone is on crack just like my uncle. Damn, Mr. Buka, you sound like you on butt. Ricky, come on, Selena, we want to hear from you. Yeah, Selena. How long before you get home? Cause we got some content that we'll be able to do while you driving. Belina. Hey, blood, Belina. You said you was gonna read the paperwork, bro. 5 minutes. Okay, that's cool. We got something for 5 minutes. So let's go ahead and go to this. So we're going to go back to when it first started with CS2 Back. Because a lot of people been misinformed talking about Deuce Sims was on what's his name team. I don't know how I was on his team. Nigga, if I'm on it. What up, though, IJ Boy TV? Salute. Let me see where the hell is this thing at. Hey, salute to everybody. Kurt Hoolam. Hey, y'all got Kurt Hoolam block. Salute Kurt Hoolam. We're gonna try to get you up in there. You know what I'm saying? He said they got him blocked on I know how to unblock people, but it's gonna have to be after the thing. Team, please remind me to unblock the brother after the live is over.
Deuce.
That's Barat. Yeah,
Selena name start with an S. You know they Belina Barat. They starting in the chat, bro. Salute to the chat, man.
All right, let's get into this real quick. This is the first time. It should happen when we
This Lamonte do send from Brims, right? FHN. So now we talked about
no, wait, slow down. What FH what that mean, nephew? So I know what that means. You said a bunch.
LA Brims, that's what it means. You from LA Harvard? I'm
trying to set some shit up.
If Fruit Harvard Nets, if you was tapping in with the homies on the West, you would know a little bit more about it. Right?
We say 5 times.
Hey, listen, man. For those that ain't from the streets and don't understand what just happened, I said this is Lamonte, Deuce Sims from FHN. He said, hold on, nephew. You said a whole lot. I don't know what is that. I said Fruit Harvard Nets. He said, what is that? I said LA Brim. That's what it is. If you was tapped in with the homies on the West more often, you'd be more familiar. See, this weirdo is unfamiliar in them parts. You dig what I'm saying? When you get to talking about the bank days, the 20s, NHBs, the jungles, the city stones, 6 Deuce Brim, VNGs, Fruittown Brims, Inglewood families. He ain't tapped in with it. Now, he might know a couple industry cats about them sections. You know what I'm saying? He's an industry type nigga, not in the streets type nigga. He's an industry blood, not an in the streets type blood. The nigga said, no, we call it 5-time brim. Nasty work. This nigga gang goofy.
Hey, listen, little man from 6 Deuce, one of the 4 positives.
What 5-time brims? What are you talking about?
Don't know what that is? That's what I'm saying. I was tapped in, right? It's 5-time brim, right? You know what I'm saying? So you understood what that was, right? No, it's 5 brim sets over here.
What are the 5 brim sets?
Come on.
If you gotta ask, that's a whole nother conversation.
Wait. You said there's 5 brim sets. What are the 5 brim sets?
6 Deuce, Black P Stone, G, 21st Street.
21st Street is Black P Stone.
2 different sets, though, homie. That's 2 different neighborhoods.
Okay, that's 4.
Black P Stone is City Stones and Jungle Stones.
That's 2 different neighborhoods, bro. 20. When a nigga tell you I'm from 21st
but they're
Street,
both Black P Stones.
Don't matter. They got 2 different.
Hey, hold on. Let's make sure that my audio is fixed. Hey, is my audio still messing up and breaking up? Let me know.
I can hear you. I mean, shit, I can hear you clear. I don't know if anybody in the chat, somebody was saying your shit sound distorted. So, I mean, but I can hear you though, bro.
They said the bound is bad. Deuce, your thing is what you call it. Let me make sure my my internet access is good. Yeah, am I still choppy? Hold on. Okay, let me see what time is it, because it said 8:31. Yeah, get ones in the chat if I'm sounding a little choppy still. They said it's static. Stay here, y'all. Hold it down. They can hear you, but they can't hear me, so I'm going to shake, and then I'm going to come back.
Man, you already know what it is, man. Y'all sitting on one of the hottest lives on YouTube right now. You sitting with Deuce M's, the Don, and y'all L, the Kiwe pop star. So, you running too much content, huh? Well, I don't think we're running enough. Salute to everybody that's in the chat right now. Salute to the chat. You already know that's where it's at. Deuce Sims is getting his technical situations together. But we still gonna hold it down together, man. I'm about to leave the plantation soon. And I can't find my charger. This shit is crazy.
How that sound? Let me get a 1 in the chat if y'all can hear me. Let me get a 1 in the chat if y'all can hear me and I'm not choppy. They say yours is choppy too. Tell them on Clubhouse. Yeah, oh man, they saying that all our stuff is done. Bad. Okay, 1. Drew V said I'm better. Can we get some more ones that my audio is a little bit better? Okay, Miss Lisa, thank you. Hit that like button. Dobie said it's still choppy. Yeah, they saying it's cool, Dobie, better. Okay. Let's get back to the content real quick. No, they said it's not. Okay, yeah, tiny bit, but it's still too choppy. Why is it so choppy, bro? Let me see if we can fix this audio. The hell? Echo cancellation. Defaults, reduce mic background noise. Okay, now hopefully that'll be it. Automatically adjust mic volume. Okay, so let's go. Yeah, I don't know what that is. That might have to just be their thing, because Let's see if y'all can still hear this. Ain't no restarting the live. That's what we ain't. Oh, okay. Restart from the beginning. We'll do it like that. You right, King. You know what I'm saying? Let's go on this. Boom. We was only a couple minutes in. Let's go.
I'm coming. I'm
You
coming.
want to fight who, Wack?
No, he want to fight my little homeboy. This Lamonte do send from Brims, right? FHN. So now we talked about
Now wait, slow down. What FH? What that mean, nephew? So I know what that means. You said a bunch.
LA Brim. That's what it means.
You from LA?
Harvard.
I'm trying to set some shit up.
It's Fruit Harvard Nets. If you was tapping in with the homies on the West, you would know a little bit more about it. Right?
we say 5 times, bro. Hey, listen. Little man from 6 Deuce, one of the forefathers.
What's 5 times Brims? What are you talking about?
Don't know what that is? That's what I'm saying. I was tapped in, right? It's 5 times Brim, right? You know what I'm saying? So you understood what that was, right? It's 5 Brim sets over here.
What are the 5 Brim sets?
Come on. Politics.
If you gotta ask, that's a whole nother conversation.
Wait. You said there's 5 Brim sets. What are the 5 Brim sets?
6 Deuce, Black P Stone, G, 21st Street.
21st Street is Black P Stone.
Different sets though, homie. That's 2 different neighborhoods. That's 2 different neighborhoods.
Okay, that's 4.
No, Black P Stone is City Stones and Jungle Stones.
That's 2 different neighborhoods, bro. 21. A nigga tell you I'm from 21st
but they're
Street.
Both Black P Stones.
Don't matter. They are 2 different neighborhoods, my nigga. 2 total different sections.
Hey, Lamar,
they don't same neighborhood, my nigga.
Do Sims from Brim, LA Brim.
Oh yeah, hey Wack, I heard it, cuz. I'm from Harlem. I'm a slideshow from Harlem, but I heard it, cuz. He from there.
He from LA and New York.
Nah, you on the defense.
Are you from LA or you from New York? I'm just
LA,
asking you a
South
question,
Central
LA.
He from LA. He from LA. I heard it, cuz.
Yeah, you said some shit that I didn't know what the fuck it meant, so I'm gonna ask you what it means, my nigga.
No, and that's why I made the statement I made. You said which one? I said FHN. You said what is?
Nigga, you said some shit that I didn't know what it means. FHN. This nigga said he don't know what FHN is. You know what I'm saying? That's nasty work. Nasty work. The initial anti-Crip set, you talking about on Paru this, on Paru that, and you don't know about the first anti-Crip coalition? Yeah, you're not tapped in like you claim you is. Maybe you had Big U dick too far down your motherfucking throat, nigga. Let's go.
Is that? I said if you tapped in with the homies on the west side of South Central more often, you'll be more familiar.
Selena.
That's what I said.
But no, but that's what you're not understanding. My uncle, he tapped in with everybody, my nigga.
We finna get to it right now.
How you gonna tell me what I know? I'm not.
You can find the paperwork.
Right. I'm gonna pull the paperwork up. We're gonna get back right there. Y'all remember, after we finish with this update on WACK100's civil suit for defamation against Worldstarhiphop, related to my documentary, WACK100 exposed as federal informant. So we're going to pull this up. As soon as we do, we'll let Selena take over since she graced us with her presence today. Hello, Selena.
Hi.
Hello, Selena. Hey, what up, Belina? Hey, Belina. Hey, Belina, I got something to ask you. Hey, you ready for the winky wink and the pinky pink?
Absolutely not. My fingers are
Hey,
going nowhere near your ass.
I didn't say nothing about my
I already
BBL
know.
rectum.
We already know all about you. We know what you like. We know what you do. It's a no.
Hey, on Pyro, you don't know nothing I like. And I'm
Paru, no.
Hey, read the paperwork.
Did I just shut you up?
Yeah, you
Wow.
shut CS2 back down, Selena. Belina.
God, this is really hard to see. You're gonna have
You
to have
got
it
your
on the
copy
screen.
on your phone?
I'm having a hard time pulling it up. Hold on. I was gonna read it off your screen, but give me
I can
1 second.
blow it up a little bit more. Hold on.
Okay.
Let me try to accommodate you. Hold on. We're gonna blow this thing up a little bit more.
Thanks.
Okay, is that better?
Yeah, kinda. You know what? Hold on. Why don't you let Yael make some jokes for a second while I do this?
Yael is full of BS. You know what I'm saying? Dukes, how you doing tonight, brother? I hope you're having a great night, sweetheart. Much love. Much love to you, Stacy Taggart.
She's so sweet.
Yeah, she's so sweet. We needed that
She
energy.
is.
You know what I'm
Hey,
saying?
Stacy. Hey, video chat me. Video bat me so I can. Bro, every time I think about
chat you.
Oh my gosh, bro.
Laugh out loud. The Brims date all the way back to the 60s in East Los Angeles. Yeah, Liso Village also. You're 100% right.
Oh, man.
Let me know when you're ready, Selena. Till then, we're going to be in the chat. Senior General Trab, Damu Kiwe conversations. Get active, chumps. Salute. Drew V. Salute to Shaw Caller. Look at how hard CS2 Back tries to act like he's the expert on LA, but he don't be knowing shit except what he heard. Right. Drew V, what it do? Brim Shifty, he a fool, fraudulent wannabe. Hey, Brim Shifty, you know if this nigga don't know what FHN is in 2020 something, then that nigga really ain't gang, my nigga. He a fool, fraudulent wannabe, but he a blood. That MF need to stop. We see you, MF. Shorty doo-wop. Damn, Selena. Okay. Look, they got 3 eyes on Selena. They trying to shoot they shot. They looking.
Shut up.
They all up in her back trying to see the pictures on the wall. You know, these some nosy people in the chat.
I know. Why is he so nosy?
Slim Gang TV said, Belina. Dominique Wells, salute, Belina. M&M's get that stove ready. Oh, y'all know I'm a cook. I'm just waiting on Selena. She gonna bless us with her presence today and reading. Now look what she say to Yael. Salute, Yael. How do you do, my brother? I hope you're having a wonderful day today and a great night, love.
She's so
sweet. Yeah, she is.
Sweet.
I'm saying Gregory Womack, like Bobby Womack. You know what I'm saying? Miss Lisa. Belina sound beautiful. Selena said no finger for CS2 Back's BBL. Damn. Oh, pure food. Yeah. Where the hell he done fell off? You clean, bro, yo. Oh, yeah, they clowning. This bumper got knocked off. This bumper got knocked off by Selena. Stacy, blessings and thank you. She better watch out. He talked the dog. You know what I'm saying? He talked the dog. Let's go. Okay, Selena, so I can officially erase the Mexican voice out of my head now. She do sound Mexican. Like Americanized Mexican from the valley. You know what I'm saying? He could have said 6 Deuce, Fruit Town, VNG, so on. Yeah, but he don't know. He basically what he's supposed to say. Well, there's 4 brim sets left. Black Pea Stone, Fruit Town, Hard Park, Van Ness. That's what he's supposed to say. But he said it was 5, and he didn't even get to name the Fruit Town. He's 6 Deuce. He didn't even say Harbor Park. 6 Deuce. Black P Stones. Y'all, what the deal, Hub? The Hub in this building. I don't know where he went. He'll be coming on. West, cuz. What up, Money Grip? Salute, man. I haven't seen you. Yeah, man, hit the button. The chat is lit right now. Let's go. Money Grip. CS2 Back, never been in these South Central streets. Yeah. Well, he used to hide up under Big U. No diss to them, but since when is Pacoima LA? I'll wait. They LA County. You know what I'm saying? Salute to Damu and Kiwe conversations. Real ones with real content. The revolution is televised. We are the revolution. Black power. You know what I'm saying? King McCauley, salute, champ. They in here, Mr. Souls. I got soul. You know, I'm super bad. Hood Tycoon, salute Deuce, y'all. Peace to the chat. Salute, peace. Selena's still trying to get her eyes right. You got your reading goggles on your bifocals. You know what I'm saying? No BS. Mike B, the boy won't leave his crib. On God, I think he quit his job. He know when I catch him what it's gonna be. Drew V, Miss Lisa. So Selena done dropped out. Yael done dropped out. You know what I'm saying? But they'll be coming back on. Expo Line, salute, what up? Mike B, Money Grip, West LA trades up. Hey, y'all hit that like button. I talked to dog. You know what I'm saying? We got the content. A lot of people have been asking what's going on with the update on Belinda is disclaimed. What's going on with the Worldstarhiphop lawsuit? They taking a long time, so we're going to get into it until they come back. Selena Gregory Womack came through looking more like Bobby Womack. When I beat you, you going to bed, nigga. Yeah, I was saying, we outside, cuz. I seen an interview with a New Jersey Rolling 60. He said 600 and lose with reputable 60 members. Oh, shit. Lawsuit. Yeah, Street TV's in the building. Salute to Alex Alonso, and I'm going to go ahead and start taking off on this one. She talked about she have an issue. It's okay. When you get back, I got you to the yeah, this is an update on the lawsuit from my video. Worldstarhiphop, WACK100 filed a defamation lawsuit against Media Lab AI Inc., which is the mother company, the parent company for Worldstarhiphop. So let me get into this now. KG, salute. He thought you were from NY from what it sounds. He thought he could fat mouth like he really that guy. He not that guy, bro. Wait till we get into that because it's so humiliating. It's 5 Brim said, hey, homie. But anyway, Superior Court. So here you have it. Civil Division, Central District, Stanley Moss Courthouse, Department 68. And then you have the number. And then you have Cash M. Jones versus Media Lab AI Inc., a Delaware corporation. Judge Honorable Stephen P. Fowler, right? Judicial Assistant Shantae L. Warren, and courtroom assistant Terry Scott, right? So, appearances for plaintiff, no appearances, okay. Nature of proceedings, ruling on submitted matter. The court, having taken the matter under submission on February 24th, 2025, for hearing on special motion to strike under CCP section 425.16, anti-SLAPP motion filed by defendant now rules as follows. The court orders the tentative ruling is adopted as the final ruling by the court. The defendant's special motion of defendant to strike complaint filed by Media Lab AI Inc. a Delaware corporation on 9/10/2024 is denied. So, anti-SLAPP laws protect rich people who utilize their resources and to silence people violating their rights to free speech, etc., etc. So there was the judge made a tentative ruling adopting the final ruling by the court, and they also struck down the motion to by the defendant, which will be Media Labs, to strike the complaint in its entirety up under the anti-SLAPP laws, which was filed September 10th, 2024. A summary of action. Plaintiff, Cash Jones, pseudonym known as WACK100, alleges defendant Media Lab, AI Inc. Media Lab operates on website identified and located at worldstarhiphop.com with an official channel on video streaming platform YouTube. On February 27, 2024, a video entitled WACK100 Exposed for Being an Alleged Federal Informant documentary. I hope y'all pay close attention to the title, because I strategically titled that documentary that. WACK100 Exposed for Being an Alleged Federal Informant documentary. So we interviewed Mark Stevens, we interviewed Stutterbox, we brought the paperwork, and we got clips from WACK100 himself. So all that we put was the statement from the victim of the Main Street alleged kidnapping, robbery, beatdown, and we got one of the targets of the investigation, Money Mark Stevens, as WACK100 asks. You want to know what? Ask Mark. He knows. He the one that tried to hook up the three-way. So we went and asked Mark, and we put it together and said that he's being an alleged federal informant. So that alleged, and we did it as a documentary, which is the best we could do. We weren't there, but we have substantial evidence that tends to lend credence to their statements. Now, it was published on YouTube via the Worldstarhiphop channel. Facts. The video represents plaintiff was somehow involved in a criminal enterprise which led to plaintiff's arrest in an unspecified location and police force, but was later identified as a confidential source of information by the Federal Bureau of Investigation. The video obtained certain notoriety and popularity, which plaintiff alleges constitutes untruthful statements of criminal behavior and tarnishes his reputation. On July 8, 2024, plaintiff filed a complaint for defamation, libel, and or slander. Let me make sure they ain't came back, because oh yeah, Yael in here, and I just got him sitting down there. My bad. I'm so glad I checked.
Good.
Okay, on August 30th, 2024, Media Lab AI Inc. answered the complaint. Superior Court of California County of Los Angeles Civil Division on February 25th, 2025 at 11:03 a.m. ruling denied evidentiary objections. Declaration of Andrew Wagner Trugman overruled, not relied upon. Number one. Declaration of Daniel Cotton overruled. Declaration of Cash Jones overruled. Plaintiff entitled to assert claims and opinion. Not hearsay. Not offer for truth of the matter asserted in asserting defamatory statements. Objections not numbered. Declaration of Justin Truban overruled. Counsel qualified to make statements. Not hearsay. Not offer for the truth of the matter asserted. Objections not numbered. Jones objections to the reply overruled. No actual identification of specific content. Plaintiff may challenge new argument in the reply, but not via unspecified evidentiary objection. Request for judicial notice granted. The court take judicial notice as to the existence of the purportedly defamatory videos as posted on YouTube by defendant publisher, but cannot take judicial notice of any content for the truth of the matter asserted in any linked video. Defendant Media Lab AI moves to strike the entire complaint for defamation, libel, and or slander per se on grounds that the complaint was filed as a retaliatory act for publication of the First Amendment protected conduct in the posting of the documentary entitled WACK100 Exposed for Being an Alleged Federal Informant documentary. Media Lab also contends Jones cannot prevail on said defamation claim due to both statutory protections under the Communications Decency Act. I gotta look that one up. I'm not hip to that. That's 47 USC subsection 230 CD8, and denial of the ability to state a claim for defamation under the elements as to a public figure. Plaintiff Cash Jones, pseudonym known as WACK100, in opposition denies any First Amendment protections and that no public issue was addressed and the documentary was instead published with malicious intent in order to cause reputational harm. Jones maintains the defamation claim is properly alleged, supported with sufficient evidence, and not subject to CDA protection. Media Lab, in reply, emphasizes the publication of the statements constitute a matter of public interest in a public forum and denies any probability of prevailing on the merits based on CDA protections and lack of defamatory content. So they're saying there is no defamatory content in this documentary and that you don't stand a chance of winning this in a trial. Oh, they said drop the link again. Hold on. Let me drop this for Selena. Belina, blood. Paru. Belina, you keep going down. Pause. Yeah, you with me? Can you hear me, bro?
100%.
Okay, well, do you know how to pull people up when they come up here?
No, I do not, sir. Unless you got to show me in the back channels or something.
Okay, well, let me get back to it. And if you see her up here, just hey, whoa, you know what I'm saying?
Say that.
All right. So we're going to read up on the CDA protections also. But anyway, boom, February 25th, 2025. Code of Civil Procedure, Section 425.16 provides that a cause of action against a person arising from any act of that person in furtherance of the person's right of petition or free speech under the United States Constitution or California Constitution in connection with a public issue shall be subject to a special motion to strike unless the court determines that the plaintiff has established that there is a probability that the plaintiff will prevail on the claim. So this is the standard under the United States Constitution and the California Constitution of the Code of Civil Procedure as it pertains to anti-SLAPP laws, right? And free speech. So basically, any cause of action like this lawsuit against a person arising from any act of that person in furtherance of the person's right or of petition or free speech, which is my right for petition or free speech under the United States Constitution or California Constitution in connection with a public issue shall be subject to a special motion to strike, which means dismiss this lawsuit unless the court determines that the plaintiff has established that there is a probability that the plaintiff will prevail on the claim. So it doesn't mean that he will prevail on the claim in a trial, but that there's a probability that he could. Basically, there's a case in law that he has a possibility of winning on this. The new updated ruling basically means that the judge found that there is a probability, not an actual possibility, but a probability, right? So Civil Code of Civil Procedure, subsection 425.16, subdivision B. Such a motion involves a two-step analysis in which the court must first determine whether a movement has made a threshold showing that the challenge cause of action is one arising from protected activity. Then they cite the cases, and if the court so finds, it must then examine whether the respondent in this case would be Worldstarhiphop Media Lab, right, has demonstrated a probability of prevailing on the claim. An act in furtherance of a person's right to petition or free speech under the U.S. Constitution or California Constitution includes: 1, any written or oral statement or writing made before a legislative, executive, or judicial proceeding, or any other official proceeding authorized by law. 2, any written or oral statement or writing made in connection with an issue under consideration or review by a legislative, executive, or judicial body, or any other official proceeding authorized by law. 3, any written or oral statement or writing made in a place open to the public or a public forum in connection with an issue of public interest. With an issue of public interest. Yeah, we're going to definitely have to consider that.
Hey, Wood.
What up? All right, let me get her up here. My bad. You know what I'm saying?
I told you, Damu.
I don't see her.
Hey, Belina, get your ass on stage.
I talked to Bernard. CS2 Back miss having that big U thing down his throat until he went on a smear campaign. I can't stand that dude. We done dropped the link again. How many times we got to drop the link? Let me finish this, man. So, the anti-SLAPP provisions apply where the allegations of the defendant's protected activity are the gravamen or principal thrust of the cause of action. And they cite Peregrine Funding, Inc. versus Shepard, Mullen, Richter, and Hampton, LLP, 2005. Where a cause of action alleges both protected and unprotected activity, the cause of action will be subject to section 425.16 unless the protected conduct is merely incidental to the unprotected conduct. If the allegations of protected activity are only incidental to a claim based essentially on non-protected activity, the mere mention of the protected activity does not subject the claim to an anti-SLAPP motion. Martinez, and they cite the case, right? We conclude it is the principal thrust or gravamen of the plaintiff's cause of action that determines whether the anti-SLAPP statute applies, and when the allegations referring to arguably protected activity are only incidental to a cause of action based essentially on non-protected activity, collateral allusions to protected activity should not subject the cause of action to the anti-SLAPP statute. Whether the defendant act qualifies as one in furtherance of protected speech or petitioning will depend on whether the defendant took the action for speech-related reasons. The mere fact that an action was filed after protected activity took place does not mean the action arose from that activity for the purposes of the anti-SLAPP statute. Moreover, that a cause of action arguably may have been triggered by protected activity does not entail it is one arising from such. In the anti-SLAPP context, the critical consideration is whether the cause of action is based on the defendant's protected free speech or petitioning activity. Navalier versus Slayton. Courts must draw a careful distinction between a cause of action based squarely on a privileged communication and one based upon an underlying course of conduct evidenced by the communication. In determining the application of the special motion to strike statute, the court focuses not on the label of the cause of action, but on the underlying activities alleged in the challenge pleadings. If the court determines that relief is sought based on allegations arising from activity protected by the statute, the second step is reached. A plaintiff cannot frustrate the purposes of the SLAPP statute through a pleading tactic of combining allegations of protected and non-protected activity under the label of one cause of action. The anti-SLAPP statute's definitional focus is not the form of the plaintiff's cause of action, but rather the defendant's activity that gives rise to his or her asserted liability, and whether that activity constitutes protected speech or petitioning. The anti-SLAPP statute does not apply where protected activity is only collateral or incidental to the purpose of the transaction or occurrence underlying the complaint. The mere fact that an action was filed after protected activity took place does not mean the action arose from that activity for the purposes of the anti-SLAPP statute. Moreover, that a cause of action arguably may have been triggered by protected activity does not entail it is one arising from such. In the anti-SLAPP context, the critical consideration is whether the cause of action is based on the defendant's protected free speech or petitioning activity. So that's what the court had to decide under this motion to dismiss under the anti-SLAPP laws. Basically, Worldstarhiphop's parent company, Media Lab, is filing that what Wack is trying to do is silence people because he has resources and money, and that is trying to silence a person's freedom of speech. That's in layman terms. The court may consider the declarations in support of in determining whether moving party meets the threshold for shifting the burden in the special motion to strike. Code of Civil Procedures, 420, subsection 425.16, subdivision B2. They cite Stewart versus Rolling Stone, LLC, 2010 case. The court interprets the activities of the parties through the allegations in order to determine free speech activity, but need not adhere to the strict form of the operative pleading in order to make such determinations. Protected activity. Plaintiff, meaning WACK100's attorneys, offers no dispute over the legally supported argument establishing the existence of YouTube as a public forum for purposes of considering protected speech activity. Barrett v. Rosenthal, cases construing the term public forum as used in section 425.16 have noted that the term is traditionally defined as a place that is open to the public where information is freely exchanged. Under its plain meaning, a public forum is not limited to a physical setting, but also includes other forms of public communication. Statements accessible to anyone visiting a website constitute public forums. The debate focuses on the threshold issue of a matter constituting public interest. Code of Civic Procedures, and then they cite it again, but this time it's subdivision E3, right? Defendant, so this is this is Worldstarhiphop, relies on the identification of plaintiff, WACK100, as a public figure, and therefore any information regarding potential transactions, relationships, and or other statements reflecting on societal interactions reflexively constitutes a matter of public interest. What a hell of an argument. Of course, okay. Sorry, Selena. I was reading and didn't even see when you came sitting backstage. I think she got to come to the front stage for me to see her, to pull her up anyway. But yeah, come on if you want to, Selena. But if you're busy, I got your back. So that's a hell of a legal argument, right? It is public interest, which is what the law is requiring, because he's a public figure. So people who are public figures are spoken upon all the time, right? On social media and in public forums. So hell of an argument, right? Any issue in which the public is interested, whether significant or not, can constitute an issue the public takes an interest, where the subject is a public figure subjecting themselves to inevitable scrutiny and potential ridicule by the public and the media. In other words, CS2 Back, get out your feelings. As it comes with the territory. Right? Plaintiff carefully seeks to distinguish such a potential sweeping inclusion by first denying any public persona and instead characterizing the conduct of plaintiff as a behind-the-scenes manager promoting the clients. Plaintiff additionally addresses the standard requiring consideration of the actual underlying nature of the speech itself rather than reliance on generalities. So what they saying is that CS2 Back is trying to say, I'm not a public figure no more. I got audio where he said, you can love it or hate it, but I'm a public figure. Now he's trying to say, oh no, I'm behind the scenes, a manager promoting the client. You know what I'm saying? More specifically, plaintiff rejects the synodic theory, I think that's how you pronounce it, synodic theory of public interest, whereby a part of a statement or portion of conduct becomes relied upon to represent the entire basis of determination regarding public interest. So what they're saying now is that based on a portion of the conduct, I throw the ball and somebody says they were hit with the ball, then in the interest of public, I can represent the basis and determination regarding the public interest, say that Deuce Sims threw a baseball that hit somebody in the head. I can make that conclusion. Whether or not that's what actually happened, that's what it appeared to be. And you being a public figure, that would not be defamation, even if the baseball actually missed them and we later find out this person was lying, right? The inquiry under the catch-all provision instead calls for a two-part analysis rooted in the statute's purpose and internal logic. First, we ask what public issue or issue of public interest the speech in question implicates. A question we answer by looking to the content of the speech. Second, we ask what functional relationship exists between the speech and the public conversation about some matter of public interest. It is at the latter stage that context proves useful. Filmon.com Inc. versus Double Verify Inc. But the catch-all provision demands some degree of closeness between the challenge statements and the asserted public interest. But ultimately, our inquiry does not turn on a normative evaluation of the substance of the speech, we are not concerned with the social utility of the speech at issue or the degree to which it propelled the conversation in any particular direction. Rather, we examine whether a defendant, through public or private speech or conduct, participated in or furthered the discourse that makes an issue one of public interest. A few guiding principles may be derived from decisional authorities. First, public interest does not equate with mere curiosity. Second, a matter of public interest should be something of concern to a substantial number of people. Thus, a matter of concern to the speaker and a relatively small specific audience is not a matter of public interest. Third, there should be some degree of closeness between the challenge statements and the asserted public interest. The assertion of a broad and amorphous public interest is not sufficient. Fourth, the focus of the speaker's conduct should be public interest rather than a mere effort to gather ammunition for another round of private controversy. Finally, those charged with defamation cannot, by their own conduct, create their own defense by making the claimant a public figure, right? Well, we're not saying he's a public figure. He got a blue check and all kind of other stuff. So this is going to go, look like it might be going left for this nigga once they get to proving all of the points that he is a public figure. A person cannot turn otherwise private information into a matter of public interest simply by communicating it to a large number of people. Plaintiff, WACK100, characterizes the underlying core of the alleged documentary as arising from purported involvement in a conspiracy to commit murder and an informant relationship, right? Plaintiff denies the subject matter in any way contributes to public discourse or even whether such discourse remains incidental to the professional life of a plaintiff. So, now they're saying that WACK100 denies the subject matter in any way contributes to public discourse. So basically, he's saying that we don't got a right to have discourse on whether or not he's CS2 Back, nigga. This is his legal argument, nigga. He doesn't believe that we should have a right to discuss publicly as discourse whether or not he's working with the federales, right? That's not an interest of him. I'm not a public figure. This is what he's trying to argue to the courts. His lawyer is going to get whooped. Nigga, that shit is garbage, nigga. Hold on, let's see where we at. So, let's get back to it. Nasty work, man. Nasty work. So, here we go. The focus must still remain on the specific nature of the speech itself. The court appreciates potential exploitation of alleged socially distasteful or even illegal celebrity conduct for purposes of generating viewership traffic in favor of content providers. Politicians and athletes may also be subject to public scrutiny. The intended target may, however, challenge said exposure. Now, mind you, we're not even talking about the fact that he has falsely accused me of and did the exact same thing he's arguing against, right? He says I'm a nobody. So how would he argue to the court that I'm a public figure and he has no difference is I got evidence that this dude was working with the people, that this guy was arrested, etc. I have never worked with law enforcement. I've been in jail most of my life because that ain't even in me if I wanted to do. But wait till that evidence comes out. This nigga argument gonna be weak as hell. So The special motion to strike specifically requires the court to consider the balance of whether such publication of alleged acts presents a public interest, limiting the aggrieved party's efforts to limit exposure and mitigate damage, or whether the claim should proceed towards further adjudication. To the extent a person seeks to capitalize and monetize individual image, behavior, and preferences, intentional exposure for said purposes, including through social media, can constitute a willingness to engage in public interest, consideration of perhaps unintended aspects of one's private life. The court, however, remains mindful of the denial of any public persona engagement by plaintiff. Wait a minute. So the court remains mindful of the denial of any public persona engagement by plaintiff, and otherwise finds no particular support from the defendant of a person seeking to capitalize on a certain media-based public enemy. So one of the reasons that Worldstar didn't get the anti-SLAPP law granted is because they failed to produce evidence that WACK100, the plaintiff, was seeking to capitalize on certain media-based public image. So their lawyers already dropped the ball, because had they did that, the ruling on the anti-SLAPP laws might have been different. While a public figure becomes an evolving term as media becomes more democratized with internet-based content providers pervading society in multiple realms, the court still finds that mere characterization of a public figure will not automatically support a finding of the voluntary acceptance of said role. Acceptance? Oh, yeah, this is good. The court questions whether a person can be involuntarily thrust into a public figure spotlight for certain conduct based on alleged interactions, presumably meant to remain private without any previously existing underlying foundation of public statement or demeanor reflecting back on said potentially hypocritical stances. His participation in Ray J and Blueface's reality shows were not quiet. His show with Loose Cannon, where he popped up on Baddies and the Beast. There are different and then his podcast, right? Where you got the 100 show and WACK100 hosted. He is and then he said it himself. He's a public figure. See, hey, Worldstarhiphop, I told y'all to tap in. We can get y'all evidence, all that evidence, and get them up over there. Y'all just got to pay me my bag first, though. Neither party particularly addresses the underlying issue of the subject matter itself. Alleged criminal conspiracy and cooperation with law enforcement. Police investigations into alleged criminal conduct in and of itself will not support a finding of public interest. Well, in the subject case, the court finds an insufficient record of a foundation justifying such scrutiny for purposes of the subject motion. The court rejects a finding that the reaction video response to the documentary in any way reflexively renders plaintiff a public figure after becoming the involuntary subject matter of the documentary. So basically, I guess Worldstarhiphop Media Lab was arguing that the documentary automatically makes him a public figure, as opposed to providing actual evidence that WACK100 was a public figure. His blue check on Instagram, his blue check on Twitter, and any other social media sites. The statistics of his name in the algorithm, right? All of the different things that he's bragged about, they didn't even bring that up. Had they brought that up, this ruling could have been ruled in a different way. They dropped the ball. Even if defendants somehow characterized plaintiff as a public figure based on a reaction video, defines the denial of the claims remain decoupled from any public persona involving the management of clients in the music industry. Also, remember this: the defendant nor the respondent, nor the plaintiff, neither party addresses the underlying issue of the subject matter itself, alleged criminal conspiracy and cooperation with law enforcement. So I hope none of y'all take that the ruling on this case means that WACK100 wasn't a rat. WACK100 wasn't arrested. That WACK100 didn't cooperate. That WACK100 wasn't CS2 Back. Because neither the plaintiff nor the respondent and defendants in this claim even addressed whether or not he was a rat or not, never addressed any of those issues at this stage of the lawsuit, right? So let's get back to it. I hope y'all able to follow. It's really complex. All right, so let's go to this. And they cited another case, allowing free reign to make any claims under the guise of protected free speech and subsequent anti-SLAPP motion will render the statute meaningless. I get that. It's not a blanket to where people can say anything. There has to be some kind of statutory limitations so that they can regulate people who actually are liable or defame people. The court therefore finds defendant fails to establish that the documentary addresses subject matter of an issue of public interest, thereby entitling defendant to seek dismissal of the defamation action via a special motion to strike. The motion is therefore denied on that basis. So, probability of success on the merits. Even if defendant established an issue of public interest, thereby requiring plaintiff to establish a probability of success on the merits, the court also finds support for the action to proceed past the subject motion. When considering the probability of success on the merits, a plaintiff must demonstrate that the complaint is both legally sufficient and supported by a sufficient prima facie showing of facts to sustain a favorable judgment if the evidence submitted by the plaintiff is credited. An action may not be dismissed under this statute if the plaintiff has presented admissible evidence that, if believed by the trier of fact, would support a cause of action against the defendant. In deciding the question of potential merit, the trial court considers the pleadings and evidentiary submissions of both the plaintiff and the defendant. Though the court does not weigh the credibility or comparative probative strength of competing evidence, it should grant the motion if, as a matter of law, the defendant's evidence supporting the motion defeats the plaintiff's attempt to establish evidentiary support for the claim. The evidentiary showing by the plaintiff must be made by competent and admissible evidence. Plaintiff maintains the complaint sufficiently articulates defamation on the content of the accusation, impugning character, lack of support for all claims based on denial of any such representations, and claim of falsely made statements for purposes of inflicting reputational harm. Assuming plaintiff acted as a public figure, plaintiff also maintains defendant fails to establish a lack of malice in the underlying conduct in libel actions. For example, public figures may prevail only if they prove that the defendant's defamatory statements were made with actual malice, whereas private figures need prove only negligence. So, this is a standard that's really going to hurt him, right? For him to win a defamation case, a public figure may prevail only if they prove that the defendant's defamatory statements were made with actual malice. that we didn't believe that he was CS2 Back, that we didn't believe Detective Michael Coet when he said that WACK100 Cash Jones was the only one arrested, right? So the 6 statements as alleged in the complaint state, there were no arrests made other than Cash Jones. Oh, this is nasty work. So this is what CS2 Back is. Hey, hit them like buttons. Y'all just in them bushes. Big U distanced himself from CS2 Back because CS2 Back went to Oklahoma and got a BBL. And we're going to come back to this. But I want to get to this real quick. So one of the first statements that he says is defamatory from my video is this. I wonder how he going to prove this to a jury. You know what I'm saying? This is nasty work. Hey, CS2 Back. You think that you're gonna convince a jury that Worldstarhiphop acted with malice and said that you were arrested, but it wasn't Worldstarhiphop that did it, and obviously Worldstarhiphop is going to believe a police officer at face value of his word. Sheriff Deputy Detective Michael Coet, the lead investigator in the Main Street case, it's going to be his word against CS2 Back, who in court on the Keefe D case was found to be not credible and had told a morass of false lies. Y'all tell me if y'all think with a one that CS2 Back got a mountain to climb to prove this first statement was defamatory. Let's go.
Oh, man. Well, first of all, there were no arrests made other than Cash Jones.
WACK100. So that's the first one, right? That's the first statement, and I'm finna get down in the chat because this is a big issue, right? We're getting into the meat on the bone. See, they ain't even got into that part yet. Oh, let me stop sharing. You know what I'm saying? The courts ain't even got into the meat on the bones and all of that. They in the anti-SLAPP technicalities type shit so far, right? So let me see. Drop a 1 in the chat if you think CS2 Back got a mountain to climb to prove that was a lie. Wack ain't got no case, but you can sue for reputational damage. Money don't have to be involved. Listen, I'm going to show y'all my lawsuit already. I'll talk to the lawyers again tomorrow. We're finna be filing. But Drew V1, Gaddafi's off his CS2 Back, then backed himself against the wall and going to expose himself. Crazy. That's exactly what's happening. Coco City 81, salute. Bruh, Wack was Wack. Wack is still Wack. Put lipstick on it. Renegade Duchess, 1, yeah, he done backed himself into it. So I take it we all believe in Detective Michael Coet when he says that WACK100 was the only one arrested. Young Yachty, oh, it's unanimous. If this was the jury, CS2 Back, your case will already be dropped. Yeah, Coco, it's a trip. It's hot today than chilly tonight. Let's see, Willie. Salute, Willie. Really Robinson. Let's see what he say. He ain't got enough lies to debunk the truth. Yeah, G-Mac and Annette Bruce. Also think Worldstarhiphop, Worldstar attorneys need to sharpen up a bit. KG, they already dropping the ball. If they give this nigga a bag, they might be hired by the feds to give him the bag. Like you said, because that was some stupid shit for them not to go get its clips on the internet talking about this case where he's saying on No Jumper, say what you want, but Cash Jones, I'm a public figure, right? You can't just say that. Let me go get that in a minute. We'll go over that later though. But yeah, everybody is unanimous. You know what I'm saying? I'm already knowing. So that's the first statement that he said was defamatory. The second statement he said was WACK100 Jones was caught on a wiretap with Del Dog conspiring to commit murder. This is why his house was raided and led him to working with the police. Now, let's get to that. Robert Ross, who was the victim in that case, stated that the reason why, let me grab that real quick. We finna get into that, and we can get back to this later. Let's go. Stutter box. All right, let's see if we can find it real quick. Oh yeah, here it go, right here. Boom. Man, this dude, come on, man. We don't want to hear you talking. All right, here we go. Let me show y'all this. So this is the other statement that he's talking about. Listen, this was the victim in the case. We believe.
You know, I've been wanting to check something, but you always got to be thinking, man, before you open your mouth. Especially if you really thinking about moving, you feel me? It should be silence and violence. You know, I want to speak on this dude keep kicking my name. I told this nigga I'ma drown his ass, homie, on Main Street. I'ma drown, cuz. Let me tell you how I meet this clown, man. This nigga all in my paperwork, man. The nigga say box, the nigga Shug won't put me on, homie. I've been fucking with this dude for a couple years. I said, all right, homie. Since you my neighbor, I'ma fuck with you. The nigga begged me to put him with game. Begged me to put him with Chuck. Holla at Chuck for me, box. Holla at Ray J for me, box. They both told me 6 times, no, no, no. I say, homie, they don't want to fuck with you. Box, they'll do it for you if you tell them to do it for you. Okay, homie. Chuck, do it for me, man. And if cuz fuck up, I'll come over there and move cuz out your camp myself. Chuck said, box, you got me? I said, cuz I got you. Changed cuz life, man. He ain't looked back. In the meantime, I'm going through some politicking with my neighborhood. You know, not finna kick no names. Rest in peace to the G, homie. You ain't saved no homies, homie. You ain't changed my daughter diaper. My son don't call you. He just took a deal for 11 years. He on his way home. Don't nobody respect you. You are J. Edgar Hoover, nigga. You know, in trans, nigga. You the police. What really fucked me up is why I decided to let this buster ass nigga know I know what he did, right? The nigga called me one day and say, box, I'm out of my truck. Where you at? I said, I'm at home, homie. He say, they own my wife at the mall. Look out for me. I grabbed the bleaky, smash up there. I see his wife coming out the driveway. I see some dudes. They most likely probably trying to holler at her. I don't know, right? But they disrespecting her her movements. So I get them up off of them. I ain't gonna say what I did, but I got the niggas up off of her. Fast forward, I'll get to some gangster shit. Nigga almost killed me and my baby mama. Put like 20 holes in my Rolls Royce. See, but where I'm from, niggas beef. 3, 4 niggas, 5 niggas get killed, and niggas squash it. This old buster ass nigga from the valley since hanging around me, he know a few people I know. He trying to reach out to the nigga behind my back to give the nigga my address, because we be stay across the street from each other, like catty corner. This damn near 20 years ago. This nigga keep kicking my name, infatuated, but he's a homosexual after 20 years. Right, you know I'm gonna drown your ass on Main Street. I'm gonna drown your ass first chance I get. I can see how, no disrespect to Nip, cuz, but I can see how a nigga drown a nigga and turn back and kick him in their motherfucking face on Main Street. But anyway, I call Wack. My Rolls Royce gets shot up. My girl almost get killed. I lay on top of her. We make it up out of there. Wack see the bullet holes in my car the next day. He reaching out, trying to contact a nigga who supposed to be the boogeyman. I know where the nigga live at, behind my back. It's in the paperwork. All on Wiretap. That's why your house got raided, you bitch ass nigga. You conspiracy to commit murder, nigga.
So, Wack is on Wiretap trying to contact the boogeyman. The boogeyman being Del Dog. Well, on the Wiretap, just like he just said, what you have WACK100, CS2 Back, the confidential source, calling Money Mark Stevens, Shaquille O'Neal business partner, saying Stutterbox went bad, the phones is compromised, I need to talk to Dog. Mark Stevens don't want to give up the phone number because he don't give out niggas math. Clicks over to call Del Dog and was going to merge them on the three-way, but he wanted to check with Del Dog first. Hey, Del Dog, back, bop, 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 bop. Why was you calling? And this is what Worldstar got to ask him when in a deposition. Why were you calling Del Dog for? WACK100? Stutterbox car, he has evidence, was shot up, and he ended up selling that Rolls Royce to Mark Stevens. So I'm quite sure they could subpoena the body shop that got those bullets up out that Rolls Royce. And you were contacting Del Dog saying that Stutterbox told on you. What did you expect Del Dog and the Main Street Crips to do to their homeboy Stutterbox? Were you just telling them, hey, look, man, y'all need to be cool? Nah, nigga. Nah, nigga. And you yourself said that you was caught up on wiretaps. Let's get into this real quick. So Stutterbox said you was caught up on wiretap. WACK100 himself admits that he was caught up on wiretap. Let's get into this. Hold on. I'm finna show y'all this one, right? Boom. Let's go. Hey, bear with me, man. We cooking. So he said he wasn't caught on wiretap.
Damu Kiwe conversations.
And I'll finish something else later. Here it go, though.
Second thing they had against me, they press play, wiretap. This is why I know when I hear certain wiretaps was conspiracy, how they'd get you. They got me on the phone. I said, yeah. All right, what you got? I said, we got a special move.
So he goes into the saying that the wiretap was supposed to be something to do with some drug transaction. Who knows? For purposes of this lawsuit, we don't have to prove what we knew. All we have to prove is what we believe. We know that you said that they told you on the upper conference room, FBI headquarters, where you saw 6 to 8 feds, and they told you that they pressed play and told you they got you on wiretap. That's kind of consistent with what Robert Ross Stutterbox accused you of. That kind of goes with what he said. So the fact that you're trying to say that it was drugs, why would I believe that it's drugs when you told us you never sold drugs? I'm going to believe what seems more likely, and that's that you found out Robert Ross gave up your name and you called the boogeyman trying to line Box up. And they got his home address, and we got proof that Stutterbox told you none of my homies know where I live at. Let's keep it that way. Do y'all want me to play that also? Let me see, because I could play that also, man. You know what I'm saying? I could play that also, man. It ain't that hard to find. The content is not that hard to find, because we got the content. Let's get to it, man. Wack speaks on how he meets Stutterbox. Oh, this is nasty work, man. You yourself admit that nobody else knew where Stutterbox lived. So how did they get the load to shoot up his house? Right? Let's go.
They got going on. Nobody never knew that but us. We the only ones knew that. So he was moving around with Shaq at the time. All-Star Weekend, Papa, actually, no, before that, he hit me.
So
Hey,
I'm
homie,
saying nobody
they
else
got
knew
going
that.
on. Nobody never knew that but us. We the only ones knew that. So he was moving around with my homies don't know where I'm at. I'm like, this nigga know where I'm at. Next morning, we met in the middle of the street. What's up, homie? We ran into each other. Listen, my homies don't know where I'm at. I be out the way. Boom, boom, boom. My kids, look like my son or your son. So, let's keep this shit cordial amongst us. Whatever them niggas got going on, they got going on. Nobody never knew that but us.
Nobody ever knew that but us. Evidence that the Main Street Crips and nobody knew where Stutterbox and his wife and kids lived except him and WACK100. And his house, his Rolls Royce was shot up with his wife in there. Almost lost her life. And he says that Wack was the one, and by the statute that we were reading, he has to prove that Worldstarhiphop publishing that documentary did it with malice and didn't really believe that this was true. That sounds pretty consistent and believable with the facts. So yeah, he up against it with that one. Let's get in the chat real quick before we go to the next prong. What do y'all think? What do y'all think? Ones in the chat if you think Wack is gonna have a hard time proving Worldstar did that with malice and didn't believe that part about the conspiracy to murder and him being caught on wiretap. Let me see a one in the chat if you think Wack is up against it by having to prove Worldstar did that with malice and didn't believe the statements that was made that was consistent with the paperwork. Come on, active in the chat. Ricky said he think Wack's up against it. Mike B said he think Wack's up against it. Degante say Wack's up against it. Blessed one say Wack's up against it. Miss Lisa. In Cali, you have to let other party know they're being recorded. Oh, that's something different. Monique Mohill say Shody Doo-Wop. AB. Lena Love. Coco City. Yaya's kids and Kid the Barber. It's kind of unanimous. Doesn't seem like Wack is all the way up against it with that one too. Damn. So let's get back to it. Let's go to number 3. Wack Jones, also referred to as confidential source number 2. Oh, this is the easiest part. This is the easiest part, right? All they got to do to prove that he was CS2 Back. Forget just the documentary. Let's go to my boy Scandalous Los Angeles TV, man. You know what I'm saying? Let's go to Scandalous Los Angeles TV. You see how easy it is? Hey, World Star, y'all better tap in with my bag or I'll let y'all burn. CS2 Back could win, nigga. I don't give a fuck. That ain't gonna have nothing to do with my money. I own the video, so y'all gonna pay me regardless. Dead homie. Nigga. So look, check this out. Right? Hit that like button, man. Share. We up in here active. Greg Caden tries to protect WACK100, right? So let's go. Oh, y'all can't see it. Let me make sure y'all can see it. Bam. All right. So let's go over here. Where we at with it?
Been compromised.
Yeah, and that's what the wiretap transcript said CS2 Back, or Wack, was calling Del Dog to do. Not Del Dog, but Mark's.
Let me pull it back, because he says this is when Wack is only time Wack was talked. This the only time Wack was talked about in the mainstream case, which he's lying, and we got the other documents. Let's back this up.
His name was in the Main Street case. No, it wasn't. Now, if Cash is asking me if his name was in the Main Street case, no, it wasn't.
So we all know that Greg is not being truthful when he says that. We can clearly see Wack's government name, Cash Jones, all in this case. Hey, Christopher Loves Boys. This shows you why you can't believe everything the police say. This also shows you that the police are protecting Wack, as they would any other confidential informant that's in good standing with them, unlike Stutterbox. But I want you to hear what Greg says right after he said Wack was not in the Main Street case at all.
There was no mention of Cash in the Main Street case. There was no mention of Cash in the Main Street case, other than when he's trying to get a hold of Mark Stevens and in order to tell him that Box has been compromised.
When he defected, that's the wiretap call that we're talking about. He's saying that that's Wack. What you finna say, y'all?
You know, the brother was trying to get on the phone with Del Dog. And I said, nah, I don't give out nobody math. You know, because when that brother defected, you know, it was, you know, Del Dog is a good dude. You know, that's the big homie. You know, and see it and Wack, he's the well-dressed lie. Defected.
When he defected, I talked to dog.
Yeah.
Right? That nigga said he talked to dog. Make sure y'all hit that like button. So, the wiretap paperwork, the wiretap, is clearly WACK100. He said he's lying because they talk about WACK100 in the extortion attempt. He was the one that brought the message to Shaquille O'Neal and Mark Stevens. That's in Money Mark's statement to the sheriff department. What sheriff detectives? The same sheriff detectives that said Cash Jones was the only one arrested. Oh, this is nasty work, Cash Jones.
Did you just see what you did? What did Greg Cadence tell Scandalous? See, you see what you did right there? You see what you just did right there?
We're going to play that right now.
Look.
That's where we at. You right in time. Listen to this.
Yeah, and that's what the wiretap transcript said CS2 Back, or Wack, was calling Del Dog to do. Not Del Dog, but Mark Stevens.
See what you just did, though?
Yeah, I said Del Dog.
You said CS2 Back. It doesn't say that, does it?
Yes, it does.
Doesn't it say CS2 Back?
Yes, it said.
So you got the lead investigator of the Joint Task Force, the Big E Task Force, Detective Greg Caden, arguing with Scandalous saying, doesn't it say CS2 Back? You just told us the only time Wack comes in is when he's trying to call Mark Stevens. And that on the wiretap, when WACK100 is trying to call Mark Stevens to tell him the Stutterbox went sour, nigga, it says CS2 Back. Wack says we made up fake paperwork and it doesn't say CS2 Back. But this lead detective has seen paperwork and he's confirming that on that call it says CS2 Back. The same one where WACK100 was at. Oh, this is nasty work, man. So we can get up out of there on that one now. Stop sharing, right? So that's another one. Let me get a 1 in the chat if y'all think that CS2 Back is up against it and won't be able to prove that Worldstarhiphop didn't believe that he was CS2 Back. Let me get a 1 because that's the standard of the law. Not that he isn't CS2 Back. The standard of the law is that Worldstarhiphop had to be had to acted maliciously and didn't believe he was CS2 Back when they put that out there for it to be. Oh, that's nasty work. Hold on, let's see what they say in the chat. I want to make sure that everybody is with us. Oh yeah, they said it's nasty work. The cover-up's been real. Mike B. Let's get to a 004. Gregory Womack, Degante Cobbins, Sagittarius Jones, Mohill 1, Bless 1, Yael 1, Drew V 1, my boy Hoover Stomp 1, Miss Lisa 1. Oh yeah, he's up against it. Ain't no way around it. Oh yeah. Oh yeah. See, they ain't even got to the meat on the bones on whether or not he's CS2 Back yet. This is
2 1 chat because I know he CS2 Back.
Right. So now that he says that was defamation. So let's go to 4. Jones has been exposed as confidential informant in paperwork recently released. Yeah, it was recently released. We already did that. Wack Jones confirmed as confidential source number 2. Yeah, we did that. We got Mark Stevens' statement. In fact, then the last one. This is all the defamation argument that Wack has added in this lawsuit. This is it. So all of that Wack Jones confirmed as confidential source. 4 Jones been exposed as confidential informant. Paperwork recently released. Wack Jones is referred to as confidential source number 2. We're able to prove all of that. Nothing has been debunked, right? Number 6. Why would the FBI be calling a big-time gangster like WACK100 Jones to make sure he's okay unless there is a relationship between the two parties, which could have started when the felon was caught in Texas with firearms? Now, for those who don't know what we're talking about, WACK100 had ran a fake play as if the FBI called his house, right? Well, let's show y'all real quick about why would Worldstar be acting maliciously. Will the FBI call your phone to question you Hold on. Let me show y'all something real quick. So y'all know Worldstar was not malicious in believing that if this call that you wanted everybody to believe came from the FBI, while the FBI does use phones for legitimate business, they will not make initial contact or first contact by phone to question. So if they did that, it's well within reason not malicious intent. And he misspelled bureau too. He put bureau with a B-R-U. You know what I'm saying? With malicious intent to believe the statement that was said in the documentary, right? The statement was, why would the FBI be calling a big-time gangster like WACK100 to make sure he's okay? Unless there is a relationship between the two parties, which could have started when the felon was caught in Texas with firearms. Now, is he trying to argue that he wasn't caught in Texas with firearms? I got to work. I got to work, nigga. Let me get ones in the chat if you think it's going to be a mountain to climb for CS2 Back to prove that Worldstarhiphop Media Lab IA maliciously lied against WACK100 and didn't believe that maybe he was working with them people if the FBI called his number on the wellness check, and if it would be malicious for them to believe that he had caught a gun case in Texas, a rifle, a chopstick, a shotgun, and a pistol, and 800 rounds of ammunition. Nothing has been debunked. Mike, hey, listen, OG Monk, that's the whole point. Wack watching, agreeing. Man, I don't even eat pork, but this bacon tastes good as fuck. Deuce, you cooked the shit out this pig. The warrior is on fire. Fact, AB. He misspelled burrow too. Deuce, yeah, I know. You know we got the content. Wack sitting back like that boy good. Give it up for the sexual chocolate. The burro. The burro like a donkey. That boy good. That boy good. Make sure y'all go hit that like, thumbs up. Man, we cooking and y'all still can't hit the like button. Man, there's some haters up in here, man. I think the fans up in here tonight, man. You know what I'm saying? The fans is up in here. But we gonna cook them rap-loving motherfuckers. They belling the truth on me, blood. Bless one. Hell yeah. Oh, yeah. So even the last one, yeah, CS2 Back put burrito instead of bureau. Yeah. Because Wack is a victim, documented. Selena DeGante, yeah, man. So let me see where the ones at. What y'all think? Does the FBI have to contact you by law if there's a bag on your head? Hell no. They knew it was a bag on Pac head. They knew it was a bag on Big Head. He rolled up like a burrito. Roll it up. So let me get ones in the chat, man. Let's stay active and interactive. Let me get ones in the chat if you think that CS2 Back is going to have a hard time proving that Worldstar or Media Labs IA maliciously allowed that statement in that documentary. Let me get ones. Oh, yeah, DeGante. DeGante said he up against it, man. It's going to be a hard fight. Cash, McElroy, Joe, Miss Lisa. Miss Lisa said it's going to be a hard ride, McElroy. It's going to be harder than Mika 3 fingers, nigga. Drew V, 1 round this month. Cocoa City substates, the feds have to tell you. One all the way. Yeah, so all 6 of his arguments. Renegade Duchess, you said that he gonna hold on, Renegade Duchess, you gotta let us know why you think he could prove that's defamatory, please. Greg Caden sitting back with his popcorn watching the show like Deuce cooking whack ass. The fans will allow some shit to happen just so they can add to their case against you. Right, Ricky said, yeah, when they use him up, he's going to get what he deserved, yeah. Kid the Barber 1, Gregory Womack 1, oh, Chrissy Loveboy 006, Winnie the Pooh Bear. Yeah, he definitely Weenie the Pooh, not Winnie. Weenie the Pooh. That nigga's a weenie, nigga. Corn dog. It's going to be hard to fight, and CS2 Back just don't have that dog in him. So, look, Worldstarhiphop, y'all need to tap in and give me my motherfucking bag, or I'll just let CS2 Back cook y'all motherfuckers. Let him book y'all for the money. That means his broke ass gonna have it when my lawsuit hit his ass, because I'm coming. So let's go where we at. We back over here, right? So defendant relies on the CDA as a bar based on the characterization of its operation as a publisher for the speakers presented in the documentary. The relied upon section states in relevant part protection for Good Samaritan, blocking and screening of offensive material, treatment of publisher or speaker. No provider or user of an interactive computer service shall be treated as the publisher or speaker of any information provided by another information content provider. Oh my God. Do y'all know what that means? That the ISP or DSP, Internet Service Provider, is registered with the Copyright Office. They got to have a DMCA agent appointed and registered with the Copyright Office as registered digital service providers, right? This is saying that they cannot be treated as the publisher or the speaker of any information provided by another information content provider. So they're saying you can't hold us liable as an internet service provider for what was said through this from the content provider. Do Sims. You can't hold us liable. God damn. This nigga, hey, the law said they ain't gonna be able to hold them liable. Oh man, there's safe harbors in the Digital Millennial Copyright Act. Deuce inbox so I can talk with you. I'm MPLS only family R. Inbox. Wait, what? You gotta inbox me, bro. How I'm gonna inbox you? I don't know what your inbox is, Monk. Let me see. Did you DM me? Yeah, Active Chucks. You got an Active Chucks on IG. If you go over there right now and DM me, then we gonna be able to chop it up. I'll hit you with a few lines or something once you let me know there. Eugene, not in front of my merman. my merman. Draw. Run Deuce's bag, Mike B. Fan West TV 2, salute. Salute Active Chucks in the chat. I've been in the bushes listening, working on some new shit, but I'm going to tap in, do some keeping this goofy 100. Let's go. Hey, Fan West, damn. Section 230, the whole point of Rule 230, right? But I'm going to go to the legislative intent of the safe harbors for digital service providers. But let's finish this up real quick because everything else goes under. It's 9 pages. Any action voluntarily taken in good faith to restrict access to or availability of material that the provider or user considers to be obscene, lewd, let's say, however you pronounce that word, filthy, excessively violent, harassing, or otherwise objectionable, whether or not such material is constitutionally protected, or any action taken to enable or make available to information content providers or others the technical means to restrict access to material described in paragraph. There are 3 essential elements that a defendant must establish in order to claim Section 230. Hey, there it go. Let's go back up. Shout out to Shot and shout underscore out and tired. The whole point of 230. He's telling you guys, hey, Wack, the law is not on your side on this. You're going to crash and burn publicly, and they're all going to laugh at you because you're CS2 Back. Section 230 immunity. They are: 1, the defendant is a provider or user of an interactive computer service. That's Worldstarhiphop. 2, the cause of action treats the defendant as a publisher or speaker of the information, right? And 3, the information at issue is provided by another information content provider. Delfino versus Agilent Technologies 2006 case. No provider or user of an interactive computer service shall be treated as the publisher or speaker of any information provided by another information content provider, given that distributors are also known as secondary publishers. There is little reason to believe Congress felt it necessary to address them separately. There is even less reason to suppose that Congress intended to immunize publishers, but leave distributors open to liability, when the responsibility of publishers for offensive content is greater than that of the mere distributors. The complaint itself alleges defendant caused and or permitted the documentary to stream on the website. It remains unclear as to the actual producer of the content. So, caused and permitted the documentary to be streamed on the website. Well, under the safe harbor, I told you, one thing that the digital service provider has to do is to register a DMCA agent with the copyright office. So people with DMCA issues, copyright issues, could go look on the website and find your agent and contact them and say, look, that's my content, or look, that's defamatory. Once a digital service provider releases that, just like Worldstarhiphop got that from WACK100, if they take it down all immediately, as soon as they get the thing, like within a reasonable amount of time, then they cannot be held liable for contributory infringement or contribute as a contributor to the defamation. We're going to get to that next. But let me finish this. Yeah. I know y'all probably like, damn, this nigga do sound like a lawyer. Now, I ain't a lawyer, but I understand the DMCA. I studied that shit. Plaintiff takes issue with the definition of publisher. So Wack and them got an issue with the definition of publisher, in that YouTube provides the platform for third-party contribution, whereas defendant publishes and or distributes specifically curated content to its audience. Plaintiff cites a recent case from the Third Circuit whereby the court found where a platform provides certain curated choices to viewers, such as via algorithm, any pass-through immunity, as the neutral publisher becomes effectively compromised. What circuit was that? Oh, the Third Circuit is not going to, we're not the Third Circuit. This is the Ninth Circuit Court of Appeal that governs the Central District of California. And they're the most liberal. They're not going for that shit. Only if they are sued for someone else's expressive activity or content, i.e. third-party speech, but they are not immunized if they are sued for their own expressive activity or content, i.e. first-party speech. So, look, this is where Worldstarhiphop got, oh, sorry, y'all, gotta give me my bag, right? So, if Worldstarhiphop, and I'm going to show y'all where Worldstarhiphop sends the letter to me telling me they thought that was their content, right? Like that they own it, right? So now they're finna go ahead and say, you know what, Duke Sims, I gotta file my lawsuit ASAP. They're gonna say, hey, look, Duke Sims, you know what? That is your content. And we do owe you this money. Matter of fact, let us get you up out the way, right? So they can argue that this was not their content, right? They can't argue this wasn't their exclusive content, curated content, you know, and they ain't paid me my money. Oh, shit. World Star. Y'all thought y'all wasn't going to give me my dough, huh? Oh, don't play with my money. Listen, don't play with my money. Listen, as soon as I get this, I'm finna buy us a motherfucking house. This shit is nasty work. He about to really be broke after they have to find a new apartment. Just like you can't sue the bookstore for the book. Right. Exact same thing, Cameron. Exact same thing, AM, PM 1. You need a no-jumper interview, at least Cam Capone. Listen, I do a Cam Capone. I'm not going up to no jumper. They could take my interview up off the internet and play it on no jumper, but I'm not going on no jumper. But salute Music Life. I'm surprised Cam Capone never reached out to me. I know Yael been on there. Hey, Cam Capone, blood got an issue with the brims or something on me? Oh, Yael ain't talking, huh? Yeah, we know.
No, I couldn't hear you. What you say, Deuce?
I said somebody said that I should get on no jump or at least a Cam Capone interview. And I said, nigga, fuck no jumper, nigga. I'm not going on no jumper, but they could take the content or whatever and play my content on no jumper to promote it.
Facts.
I said, but Cam Capone, nigga, why blood ain't hollered at me? That nigga got a problem with the brims or something?
Hell no. That's all he do is he fuck with hood niggas.
Yeah, I don't know why he ain't tapped in. You know what I'm saying? Cash McGill, Roy Jones, Fan West. Facebook and Twitter should have lost their Section 230 right. Hey, Cameron, you might be right. You might be right. But let's finish this real quick. I think we got like 4 more pages. The purpose of this statutory immunity is not difficult to discern. Congress recognized the threat that tort-based lawsuits pose to freedom of speech in a new and burgeoning internet medium. The imposition of tort liability on service providers. Remember I told y'all ISPs or DSPs, internet service providers or digital service providers, for the communications of others represented for Congress, simply another form of intrusive government regulation of speech. Section 230 was enacted in part to maintain the robust nature of internet communication and accordingly to keep government interference in the medium to a minimum. In specific statutory findings, Congress recognized the internet and interactive computer services as offering a forum for a true diversity of political discourse, unique opportunities for cultural development, and myriad avenues for intellectual activity. ID subsection 230A3. It also found that the internet and interactive computer services have flourished to the benefit of all Americans with a minimum of government regulation. ID subsection 230A4, emphasis added. Congress further stated that it is the policy of the United States to preserve the vibrant and competitive free market that presently exists for the internet and other interactive computer services unfettered by law or state regulations. Again, in considering CDA immunity, courts will not distinguish liability claims between a publisher and distributor when the distribution remains within the realm of publication, even in the case of repeated publications. Now, that's something else y'all need to know about copyright infringement. When you have a repeat offender in copyright infringement, the statutory damages increase. Notice of a purported defamatory statement to the publisher will not waive any CDA immunity. The influential Zarin Court opinion found a broad swath of immunity reflecting congressional intent for the CDA to allow continued First Amendment expression while minimizing potential reactive and excessive self-regulation requirements based on fear of liability arising from repeated defamatory statement notices. The CDA especially recognizes such an acute possibility in this age of internet speed and readily available means of repeated forwarding, posting said allegedly defamatory publication material. The California Supreme Court, in considering the issue under the Zarin guidelines, established a public policy stance that was careful in describing the CDA as applying to internet service providers, facilitating the process of others only passing along such information on an internet platform. The court also specifically noted balance of free expression relative to the burden of potential self-imposed regulation based on fear of notice-based defamation lawsuit threats, simply based on access to online information. They cite Barrett versus Rosenthal, Super 40 Cal 4. Now, this is California Supreme Court, which governs this court that WACK100 is in. This is court precedent and the standard that California Supreme Court holds any courts in California to. The court, however, also addressed the distinction with user liability. The statute references users in Section C2. No provider or user of an interactive computer service shall be held liable on account of, but the statute lacks a definition. The court found the plain meaning of user meant any user or entity accessing interactive computer services. ID at page 59. Defendant can present an argument that it only functions as a user or even redistributor of material to YouTube, and whether the publication constitutes active or passive contribution, the mere reposting of the documentary constitutes immune user activity. Now, for purposes of this, I do believe that WACK100 and them, if it was defamatory statements, that Media Lab IA and Worldstarhiphop might have some kind of exposure. That Worldstarhiphop, their platform, easily the safe harbors of the DMCA protect them, as well as Rule 30, right? Or 130, right? 230, right? But when it comes to subsection 230, but when it comes to them reposting that onto a YouTube channel, which is their own YouTube channel, right? It's a little bit different, right? So they might have some kind of liability that way if it was found that it was defamation of character. But as we said, each one of the allegations of being defamatory, not one of them survives the test. The liability section of the statute carefully distinguishes between the service provider and information content provider, of which latter terms appear to remain unaddressed in context of a first person versus third person expression standard. The immunity granted to the platform provider of services and those that only place material presumably published elsewhere on said forums remains resolute. An intent to shield internet intermediaries from burdens associated with defending against state law claims that treat them as a publisher or speaker of third-party content, and from compelled compliance with demands for relief that, when viewed in the context of the plaintiff's allegations, similarly assign them the legal role and responsibilities of a publisher, qua publisher, where the content provider arguably only presents an amalgam of material, third-party speech immunity protections apply, right? So presenting a curated and edited compilation of third-party speech is itself protected speech. In the case of first-party speech, however, the court found a lack of immunity in that the actions of an algorithm can be characterized as a direct expression of first-party speech. The foundational reasoning remains terse, but the analogous logic indicates a budding distinction between curated content via algorithm or by extension, human choice, and simple dissemination of information. The declarations from Wagner, Trugman, and Cotton categorically indicates an editorial directed website with specific and voluntary engagement of content screening. Wagner, Trugman declaration: the mere passing of the content onto the platform would clearly constitute protected activity. An argument can even be made that adhering to certain standards and guidelines also constitutes protected expression, right? The United States, based on the possibility for misattribution of certain content to the platform or location, right? The court finds less clear-cut support for immunity given the editorial decision to allow the publication of said documentary, in that it remains unclear as to whether the documentary was posted as a pass-through due to complying with website guidelines as a neutral platform where CDA clearly applies, or as a form of editorial expression as found in the TikTok algorithm. In other words, the selection of content for operation of a website reflecting cultural interests certainly involves curation. The selection of content for operation of a website reflecting cultural interests certainly involves curation, where the curation reflects an expressive product forming a specific identity or position of said platform. The Fifth Circuit at least finds a potential exception under first-party expression, even if dependent on third-party content. Anderson versus TikTok, Inc. The motion itself lacks sufficient address of standards for publication and review. The court declines to categorically find all content on the website was only screened with the intent of presenting divergent views, as long as no offensive or other community standards are violated, as opposed to presentation of a specific viewpoint for the point of commercial monetization. The court therefore hesitates to find as a matter of law that the editorial decision constitutes a protected third-party act, as opposed to a first-party expression of opinion akin to an algorithm presenting content to its targeted audience. The court concludes that plaintiff establishes a probability of success in the court, meaning Wack has produced a probability that it's probable that he could have success in the court as a matter of law at that stage, find no basis of immunity under the current record based on defendant presented legal and factual support. So based on this, WorldStar lawyers dropped the ball again because they say they find no basis of immunity under the current record. The record is being made by the attorneys. They didn't do their homework, or this motion would not have been ruled in Wack's favor. A WorldStar. These the lawyers I'm gonna be fighting against. Y'all niggas better holler at a nigga with that bread, nigga. That chili. The court otherwise finds plaintiff sufficiently presents the elements of the defamation claim for purposes of proceeding. The position as to previous publication of certain prior statements neither addresses nor eliminates all claims. The court also finds the claims support libel per se in the operative complaint. Plaintiff alleges conduct well beyond the law enforcement issue, which implicates character and may be impactful to plaintiff's occupation. The court finds no basis of an invalid claim based on the claim of a self-generated defamation action as addressed above. Plaintiff William Lester, salute, just got that cash app. Thank you, brother. Let me see what he said. William Lasseter, salute, man. The court also rejects the free speech discussion as both previously addressed, and due to the tersely supported discussion and lack of address as to the actual defamation standards and curbs on free expression rights. They saying these people didn't even address the actual defamation standards. Worldstar, what kind of a lawyers do y'all got? The court also declines to consider the privileged record's position in that the argument relies on inadmissible intrinsic inference requiring improper consideration of truth of certain matters. Further, nothing in the record in any way seeks to present actual content of any actual police report or even a statement from an actual investigating officer. So, all they gotta do is go get to work and then make these courts reconsider it. Why didn't they have their T's crossed and I's dotted? Why? Lawyers be lazy as fuck, bro. On opinion, they were ill-prepared for a case of this magnitude. On opinion, even assuming said documents constitute opinion, again, the selection of only certain limited items will not undermine the validity of the entire complaint. Even considering some of this position, the court's question is whether at least that portion of statement 2 regarding the existence of a wiretap constitutes an opinion or an actual representation of alleged fact, thereby undermining a conclusion of opinion within the totality of the circumstances. Baker versus Los Angeles Herald Examiner. Finally, on malice, even assuming plaintiff is a public figure, other than denial of any awareness of malicious intent by Cotton and Wagner Truman, the court declines to make a factual finding of said absence of malice simply based on self-serving conclusions. The circumstances lack sufficient factual context. The circumstances lack sufficient factual context. You're not explaining why this shit has no malice. Hey, matter of fact, Worldstar, not only do I want the money y'all owe me for using my intellectual property, millions, 4 million views total, 1 million on YouTube, 3 million on Worldstarhiphop alone. Not only do y'all, and whatever else y'all collected off of YouTube from reaction videos, not only do y'all owe me that money, after this, y'all might as well give me that money y'all was paying y'all attorneys, because them niggas suck dick, nigga. They garbage. The circumstances lack sufficient factual context, including the history of the parties and other potential awareness for the basis of the editorial decisions to publish. They didn't even, the motion is denied in its entirety. The court, man, them lawyers should be humiliated, bro. Humiliated. Whack on dollars payroll, you going to bed on payroll. Salute King Kong the Great. That is not pull payroll conversion content. Eminem, salute. Selena, stay active. It's a good look. Salute. Fed, salute. Thanks, Rob. Man, COVID over wearing a face mask to cover your snaggle tooth is crazy. I got fake teeth, nigga. I ain't got no snaggle tooth. Monetized God. Chief Quincell, salute to you, man. Cash got all that work put in. Got him, coach, on payroll, the wall closing in. Me, y'all going to bed. Salute. Get all your chalupa from their ass. Dude, man, listen, don't play with my money. You ain't got to tell me that twice. Nigga, we got a call with the lawyers at 3:30 tomorrow, Pacific time. Salute to the house. G-Mac, what's up, Bo Money? Mike B, salute Mike B, Bo Money. So that's the whole shit. And we already been in here 2 hours and 14 minutes. That's kind of long. I want to get into the chat, though. And this live over. And it may not matter how he act. But if there's a MF acting with malicious intent consistently, guess who that is? He was faking the FBI broad on the phone for the Prince family. No, that's a fact. You know what I'm saying? That's a fact. Mike B, y'all make sure y'all hit that like button, man. We over here cooking. You know what I'm saying? The police don't want to hit that like button. Y'all know they in there. Work that paperwork, dude, Sims. Mo Hill said, what's up, Bomani D. Cobbins? You know they in here. They gets the whole middle finger. Fuck y'all. Keith McCulley, Fadu, salute. Timu lawyer. Yeah, they out of pocket. Is Worldstar stupid or something? Yeah, their lawyers are. Their lawyers were ill-prepared. Ill-prepared. They just getting their check. They clean them up, dudes. Get that moolah. Man, listen. I'm finna try to make them motherfuckers file for bankruptcy. Them motherfuckers, that is crazy. So we got a couple things, and then we're going to end the live, but let me finish this chat. I'm just trying to get a feeling of everybody. Damu Kiwe, what's up? Did you need something? Nah, ETE, salute for sure, Degante. Kid the Barber, ETE for the win. Yeah, it's nasty work. So let me go to this real quick. So the FBI will not make the initial call to you off the top. They do that in person. Then they might call you. You know what I'm saying? Especially if you're working. But let's go to DMCA safe harbors for digital. Let me just put DSPs. Digital service provider. All right, so here we go right here, right? Just wanted to teach a little bit. You know what I'm saying? I told y'all I do this. Y'all need to go ahead and subscribe on Active Chucks on YouTube, a student of life, which teaches you how to properly register all of your shit. So the DMCA safe harbor provisions protect online service providers from copyright infringement liability for certain types of user-generated content. Essentially, these safe harbors grant immunity to claims if the online service provider meets specific conditions and promptly removes or blocks access to infringing material upon receiving proper notification. So the key word in this is if they promptly, quickly remove or block access to the material. So when Wack filed the defamation of character to the DMCA takedown noted to the DMCA agent for WorldstarHipHop.com, and they took it down. I think it was the 2nd of February. They took it down on the 2nd of February. That helps protect them because they promptly removed it. So conditions for protection, 4 types of protection, safe harbors for providing networks and infrastructure, caching infringing material, hosting and storage of infringing material, and linking, directing, or providing tools that point users to infringing activity. To qualify for a safe harbor, an online service provider must comply with statutory requirements, including adopting and implementing a policy to terminate repeat infringers and accommodating and not interfering with standard technical measures that identify or protect copyrighted works. Notice and takedown procedures. A key element of the safe harbor is the prompt removal or blocking of access to infringing material upon receiving proper notification from a copyright holder. So remember that it really helps Worldstar Hip Hop that as soon as Wack sent them a defamation cease and desist, that they took my video down. Now, for my case, that's going to be that's going to hurt them that they took it down and still claim my money so I couldn't publish it other places. I'm talking about on YouTube. I have not got $1 from the videos on my YouTube, not $1 from the documentary, because Worldstar is claiming it as if it's their video. So that's where they fucked up with me, right? But okay, Hood Beast. Okay, I got you, Hood Beast. Let me accept you right now. Hood Beast Bugs Primary, boom. All right, let's go. Hold on. Then we're going to go to this, because this is what we're talking about tomorrow, right? And then we're going to get up out of here. Boom. Complaint. U.S. District Court, Central District of California, complaint for copyright infringement, unfair competition against YouTube, LLC, Media Lab AI, and Cash McElroy Jones, inclusive defendant, plaintiff Lamonte Sims, a.k.a. Do Sims, then jurisdiction of venue, parties, right? Media Lab, all of them. Boom. And then it goes into the factual allegations. I'll read this to y'all. At all times relevant here too, plaintiff has been and still is the holder of the exclusive rights under the Copyright Act of 1976, 17 U.S.C. subsection 101, and all amendments thereto under the Copyright Act to reproduce, distribute, display, or license the reproduction, distribution, and or display of the documentary WACK100 and the snitch allegations known as the works, which is the subject of this action throughout the United States. Plaintiff, I am the plaintiff. Executive produced and authored the documentary incorporating the audio and audio-visual works of the work in or about 2024. The work was published in the form of a video on or about January 27, 2024 on Worldstarhiphop.com, Media Lab, a subsidiary, and January 29, 2024 on YouTube.com. Defendants monetized Active Chuck's channel. Plaintiff obtained a copyright registration number 2/482/376 on February 13, 2024. Copyright registration for the work attached as Exhibit A is a true and correct copy of the copyright registration. In or about 2024, plaintiff contacted defendants regarding the unauthorized use of the work. When plaintiff discovered the defendant, Worldstarhiphop.com was claiming monies derived from the works and that defendant had authorized Label Engine to collect on behalf of Worldstar Hip Hop. They're taking my money. See attached Exhibit B. So I send them the screenshot as Exhibit B. This occurred even after Worldstar Hip Hop had taken down defendant works from his website without serving notice and continues today. See Exhibit C, without authorization or license. Plaintiff contacted YouTube LLC, identifying himself as the actual copyright holder after receiving notice that YouTube was not allowing defendant to monetize the publication of his exclusive copyright on the Active Chuck's YouTube channel. See attached Exhibit D. So I sent the thing where YouTube isn't allowing me to make money off of my work, right? Plaintiff contacted attorneys for defendant Cash Jones after receiving notice from YouTube informing plaintiff that Cash Jones filed a DMCA takedown notice claiming exclusivity of the works. Wack claimed that my video exposing him as CS2 Back was his entirely, the whole video, right? The plaintiff's publication was removed from YouTube, and plaintiff received a strike for copyright claim. Entire video filed by Cash Jones. See attached Exhibit E. It is alleged that defendants, without authorization, copied, distributed, and or publicly displayed the work owned by and registered to plaintiff and profited financially from said unauthorized use. Despite plaintiff's request, defendants not only failed to republish works on Worldstarhiphop.com, but ignored plaintiff completely, failing to even offer him attribution or credit as the exclusive copyright holder. 16. As of the date of filing this complaint, defendants still without authorization, copied, distributed, and or publicly displayed plaintiff exclusive copyrights owned by and registered to plaintiff and profit financially from said unauthorized use. And then it goes into defendants' wrongful actions caused plaintiff severe distress. The experience detracted from plaintiff's experience of sharing the journalistic efforts of the works, resulting in both equitable and psychological damages. It is alleged that due to defendant's willful and intentional direct copyright infringement, plaintiff had to focus all of his efforts and resources on dealing with his work being taken, copied, and used without his permission. In claiming plaintiff's exclusive copyright, defendants willfully and intentionally sought to appropriate plaintiff's hard work for their own profit without bearing the cost thereof. The time commitment of developing the documentary, resources wasted to get interviews conducted, studio recording time, the digital embedding of the works, the time and cost of research, the registration with ASCAP, Sound Exchange, and MLC, the time cost of photographing, videotaping, and editing, all which was a substantial investment made by plaintiff. Defendants sought to realize the same profit without investing the same amount of time, money, and creative thought process, and to take away profits from plaintiff that he would have realized but for their wrongful acts. The work is an original work, copyrightable under the Copyright Act. Plaintiff has applied for a copyright registration with the Copyright Office. The registration number for the work is set forth in Exhibit A. Thus, plaintiff has the exclusive rights and privileges to reproduce, distribute, and display the work. Plaintiff has never authorized any of the defendants by license or otherwise to copy, reproduce, distribute, or display any other copyrighted material from the work, nor to prepare derivative works based on the work, with the exception of Worldstarhiphop.com, which was per their terms and conditions. See Exhibit F. So they have what is called a limited license. That's their terms and conditions when you put works up there. You maintain ownership of your work. You do with your work what you want. They're just helping to promote it and displaying it on their site, right? Defendants infringe upon plaintiff's exclusive copyrights to the work by copying, reproducing, duplicating, distributing, and displaying it and or derivative works derived therefrom without plaintiff's permission for monetary gain without license or authorization. Each infringing copy, duplication, sale, license, or display of the work, as well as the threat of continuing the same, constitute a separate claim against defendants under the Copyright Act. Plaintiff has sustained and will continue to sustain substantial damages to the value of his copyright, and that the previously described activities of defendants have diminished and will continue to diminish the revenues that plaintiff would otherwise receive. In addition, defendants have realized unlawful and unjust profits from their unauthorized and illegal copying, duplication, distribution, and display of copies of the work. Defendants continue to infringe the copyrights listed on Exhibit A, and unless temporarily, preliminarily, and permanently enjoined by this court, by order of this court, will continue to infringe said copyrights all to plaintiff's irreparable injury. As a result of defendant's acts of infringement, plaintiff is without an adequate remedy at all in that damages are difficult to ascertain, and unless injunctive relief is granted as prayed for herein, plaintiff will be required to pursue a multiplicity of actions. As a direct result of the conduct of defendants, plaintiff has suffered and continues to suffer damages in an amount to be determined, including but not limited to damages to his journalistic reputation. Plaintiff was unable to realize profit from his investments preparing the work, as attention for his work was overshadowed by the unauthorized copying of defendants and use of their overwhelming corporate presence to take away from plaintiff's own efforts. Defendants have committed all of the aforesaid acts deliberately, willfully, maliciously, and oppressively without regard to plaintiff's proprietary rights. And we'll get back into all of the other stuff that showing everything they allege. I just wanted y'all to get a pretty good understanding. You know what I'm saying? When I say I teach this shit, I study this shit, you know what I'm saying? I hope y'all was able to gather that, you know what I'm saying, through this whole thing. Yael, I know you been new, but what you want to speak on in regards to WACK100's lawsuit and or the civil suit that we should be filing tomorrow? Oh, y'all must have fell out. Let's go. Raider G. Let's see what they talking about. See, boom.
You hear me?
Yeah, there you go.
Now you were saying what again? Because yo, I think on my end it went out. I couldn't hear you.
Yeah, I was saying, so what do you think about CS2 Back civil suit and or my civil suit against Worldstarhiphop? Both of ours is that Worldstar. Mine just includes him, WACK100, Worldstarhiphop, and YouTube.
Right. Well, being that the historic, like you got history with the situation with Hitcho Bremen, and I mean, you sued them and you won. You sued them and won for using the music and not paying you out, and you won that case. Did it thoroughly. And were you incarcerated when that happened?
Yep. I was on the level 4 yard and filed that lawsuit in pro se, meaning I represented myself. Yeah.
And won. So I don't think Worldstar, I most definitely, I 100% know WACK100 CS2 Back isn't very privy of the intelligence that you have with the paperwork and knowing how to file it and knowing how to represent yourself, using all the correct wordage and verbiage when you're standing before the judge, you being your own lawyer, right? So the fact that when you look at the two, this is to me, this is a win-win for you, because everything CS2 Back was stating that is a counter to what you're demanding and what you're basically expounding on, as far as him being CS2 Back, that whole documentary, him using your documentary, saying that he's claiming the rights to it. Like, dude, so you're going to basically say, CS2 Back, I'm CS2 Back, and I was making a documentary about me, correct? No, you're not finna do that, bro. That's why you got the thing taken down. That's why you didn't get a follow-up email saying why that you got it. Well, did you get a follow-up email?
Yeah, later on, but like maybe 10 months later. But we got a super chat from Tarn Mystic, and it's not euros, it's the pound.
Okay, we got Tarn Mystic with the $5 pound, and you know Tarn Mystic been around. Something for the pot to help your endeavors. Salute, like, hands, Dove, and I'm dead. Hey, listen, Tartan Mystic, anything and everything that's given to the Damu Kiwe conversation team is highly appreciated. Salute to you, your family, and your tribe. But again, like this is like a no. To me, it's like a no-brainer. It's a no-brainer because everything that he's trying to counter and argue that isn't a fact, it really is. And then the whole meat of his situation, him saying that this is his intellectual property, and you put a whole documentary out on yourself, so you're going to get up there and tell the judge, yeah, this is me. I'm CS2 Back, and I put this out on myself. Come on, bro. You can't be that. Listen.
That was dumb as hell, bro.
And
imagine that. Hey,
right.
you know what's crazy? Worldstar should use that as evidence that he's CS2 Back.
And they won't have to pay him because then he's admitting it by claiming your intellectual property and the whole documentary and everything being elaborated to the full capacity, fractionalized being broken down from him telling us to go ask Mark, and you gonna go ask Mark, and Mark knows, and he's trying to get a three-way set up, etc., etc. The whole moral of that whole conversation was you try to get on a three-way, you couldn't succeed because you was defected, and you were CS2 Back in the paperwork. So you're basically going to admit that. And once you do that, it all comes out. And
I talked to dog.
You were right. And then the flip side of it is you've been already brought the receipts. You got everything down packed 100%. At the end of the day, bro, it's not rocket science. For me, it's not rocket science. I could put 2 and 2 together. 2 plus 2 is 4. And this is 4 to win for us. You know what I'm saying? So, yeah, man, I don't see how the lawyers of Worldstar didn't use none of the receipts that was being put out with
lazy. They had to be lazy, bro, and ill prepared. Yeah. So, but I'm glad they didn't, because it taught us something. First and foremost, imagine homie Big U right now.
Right.
What if Big U gets some lawyers just like $1 million company like Worldstar has that are ill prepared to represent and defend them?
Damn.
That's a scary feeling, man.
Hell yeah.
You know what I'm saying?
Hell
Them
yeah.
people went up in there playing. When the court is asking and saying, y'all didn't give none of this. Y'all didn't even argue whether or not the nigga was a rat or not. Whether or not y'all didn't even bring the paperwork. Nigga, they supposed to send private investigators to go interview Detective Michael Cohen. They supposed to send motherfuckers to come holler at me, Mark Steven, Shaquille O'Neal, Stutterbox, all of them motherfuckers. Hey, look, man, what is going to take for you to come testify to everything you told us, right? Man, give me a couple hundred. You know what I'm saying? Give me a couple 100,000. You know what I'm saying? We saving you money, you know? But nasty work, man. Nasty work. But look, Keisha, but yeah, hey, somebody was like, why did he? So what he needs to strike your content for? The truth? Wow. Yeah, bro, that's exactly what he did.
Because the truth came out and it was expounded, very elaborative, very in-depth, broken down. The key points was the major key point was him advising us to go ask Money Mark. So dudes go ask Money Mark. And then Money Mark replied and say, hey, yeah, see, I ain't talked to no Back. The lawyer told him CS2 Back was whack, and he was the one that was trying to get a three-way. And he couldn't connect the three-way because he defected. And in the paperwork, it states that CS2 Back was trying to get a three-way with Del Dog. And Money Mark Stevens was in the midst of it, of connecting that conversation. So that's the whole moral and the meat of the whole conversation, and the key points that will label him and clarify this, that WACK100 is CS2 Back. It's not hard to understand. I don't know if we're not saying it right, but it's not hard to understand, man. And this, like, for me, it's a win-win. If I was a lawyer right now, I'll be getting the champagne ready with the ice and the confetti and the poppers, and we'll be turning up right now, bro.
KG, what a hell of a statement. She said either the attorneys for Worldstarhiphop were out of the office for this, or Worldstarhiphop was persuaded to take a Don King L on this. They will apply pressure if it interferes with justice. And that might be exactly what they did. The feds might have made them not submit any of this evidence to throw the case. Like, we gonna pay for it. Selena here, dear lady. Mummy Mystics definitely doing better. Oh man, congratulations that your mummy is doing better. Thanks for asking. It's always appreciated. I hope they blessings wish for you. You are coming thick and fast. Bless their hearts. But yeah, man, this is what it is. It's on. So the cyber war is going to the court war, civil logistics, and we getting our team together. Hey, till the next time, we up out of here, man. Y'all let them know where the hell they at, man.
Man, listen, y'all done set the almost 3 hours of hot content with the receipts, man. Listen, if you was in chat, the chat is where it's at. Salute to the Blue Ridge mob that was on their job. And if you a friend that tapped in for the first time, make sure y'all like, comment, and subscribe to this content. Man, y'all done set with Deuce M's the Don and y'all L the Kiwe Pop Star. This is the voices of the culture and the West Coast. Damu Kiwe. Conversations.
We out of here.